Maybe somebody says, "Oh, I've been offended. I've been intimidated by your headwear." And they freak out. See these words here? Knowingly made, knowingly. So you have a mens rea, you have a mental state. They say it's necessary, right? People will say bad things at election polling places. And so obviously, if they're trying to regulate speech, we have to analyze it as though they're trying to regulate speech. A major win in Arizona for election integrity and free speech. You can see America First Policy Institute posted this press release, and they're referencing this order from a federal judge, United States District Court in the state of Arizona about our upcoming election. And this is an issue we've talked about a lot here, saying that various secretaries of states, like ours in Arizona, this guy's name is Adrian Fontes, and what they do now is they're not changing all of the actual rules. They tried to do a lot of this back in 2020 via settlement agreements, right? People would sue to change the election laws based on COVID. They'd enter into settlement agreements, and then there would be a court order that would adjust the implementation of the election. Similar thing is happening here. They're trying to adjust the implementation, the infrastructure of the election, but this is not through a settlement agreement that's been entered into by a friendly litigant and the government. It's now by changing the manual. They're just changing not the rules per se, but the implementation of the rules and how they accept things and how items are transferred back and forth. But what happened here is Adrian Fontes tried to manipulate and rig the election manual to serve his party and to disenfranchise voters and to curtail your free speech. And that's according to a federal judge. So we'll read through this opinion, but first it came from this group, the America First Policy Institute. They say, been a big victory. A federal judge granted both motions for a preliminary injunction and holding that the EPM and their changes were violations of the First Amendment. Here's what they say. AFPI and co-counsel Holtzman Vogel said, you know, what they tried to do here in this manual is make it a crime to engage in expression that is protected free speech. You could even simply wear a red hat. Illegal. Or you could wear a handbag that says something like, it should be easy to vote, but hard to cheat. And then you could just come under the scrutiny of our secretary. But here's what went down. In Arizona, a nice opinion from the judge. The judge says this might be the most unprecedented attempt to disenfranchise voters in America. Here's what the judge wrote. All right, listen, given the widespread controversy surrounding elections, one would hope the last people responsible for disenfranchising voters and suppressing speech, the very last people to do that would be the very election officials who were tasked with ensuring fair and accurate elections in the first place. We'd hope that they wouldn't do that. But guess what? They are. That's precisely the case here, according to the plaintiffs. Now, every odd-numbered year, the Arizona Secretary of State comes out with a new election procedures manual governing the administration of the elections in Arizona. Now, these people filing this suit, American Encore and the other plaintiffs, are challenging two of the provision changes. The first change prohibits controversial speech at polling places, or the judge says perhaps everywhere else in Arizona. We don't really know. I mean, the guy wants total power and that's how they operate. Saying that this speech provision in the manual mandates, quote, any activity by a person with the intent or effect of threatening, harassing, intimidating, or coercing voters, or conspiring with others to do so inside or outside the 75-foot limit at a voting location is prohibited. So he just wrote that in his little manual. Any activity with the intent or effect. So like if you wear a red hat, maybe it doesn't say MAGA on it, but let's say you wear a red hat in there. Maybe somebody says, "Oh, I've been offended. I've been intimidated by your headwear." And they freak out and they make a complaint. Well, that would be outside the rules. Maybe they throw you out of the polling place. Now, the rule goes on to list examples of conduct that, quote, may also be considered intimidating conduct inside or outside the polling place, like raising one's voice, using or insulting or offensive language to a voter or a poll worker. Now, if those activities occur, election officials have the discretion to remove that person and their red hat from the polling places. Now, the second rule, probably unprecedented in the history of the United States, gives Adrian Fontes, the Arizona secretary, nearly carte blanche authority to disenfranchise the ballots of potentially millions of Arizona voters. The court refers to this as the canvass provision, and here's what the canvass provision says. In the manual, he just gets to do this. He says, you know, if the official canvass of any county has not been received received by this deadline, then the Secretary of State must proceed with the state canvass without including the votes of the missing county. Wow. For example, the Secretary of State is not permitted to use an unofficial vote count in lieu of the official canvass. So if you don't get it to us by our deadline, then your votes are dead. Now, plaintiffs in this action, the people suing our government, say that this violates the Constitution in a number of different ways. And the court gives us some background on this. They say, all right, yeah, the Arizona law does give them the power to adjust and create a manual that's approved by the governor and the AG. And the speech provision initially came in 2019, so some time ago. Now, the canvass provision is a new edition of 2023. Certain addressing the certification concerns that happened after 2022, Adrian Fontes just changed the manual, the election manual, to permit himself to proceed with the state canvass without the votes of any county that fails to timely canvass the results. Isn't that amazing? I'll just take that power now. So I'm just going to reject your votes. Now, on July 31st, the secretary published a draft version of this. There was 14 days to comment. During that time, members of the legislature did express concern over that, including the speech provision and the First Amendment. But the secretary didn't change anything. After receiving approval from Katie Hobbs and Chris Mays, two ultra Democrats, the secretary then issued the final manual, right? So a bunch of comments, Republicans upset about it, but all three Democrats just decide, oh no, that's good enough. No problem at all. And they move forward with it. So now they tell us that the people filing this lawsuit, they're nonprofit people. They filed their complaint. They challenge both of these provisions, saying it violates the Constitution. Now, after filing their complaint, they moved for an injunction to stop this stuff from being implemented. And then on August 5th, the government moved to stay count 2 of the complaint and more. So now let's talk about standing, right? Standing comes up in these things a lot. Now, the first theory of harm about these changes is that the canvass provision inflicts an injury on people's right to vote. There are several cases they rely on in order to show this. Now, the existence of this scheme is like an injury in fact. Here are the reasons. First, they note that the canvass provision mandates that the secretary exclude votes from a county that does not timely canvass. So it's not speculative, okay? It's in the text. Then they argue that the refusal to disavow enforcement, so like you're going to enforce that, right? Or will you enforce that or will you not enforce that? He's not saying that he won't enforcement, so it lends to credibility. So he's like, yeah, I actually will not count the votes. In July, they sent him, Adrian Fontes, a letter saying, you're not going to enforce this, right? You disavow that. You're going to commit to some other mechanism for ascertaining the votes if the votes are not certified, right? He said, no, I'm committing to enfranchising all Arizona voters, but he will not disavow this non-discretionary statutory duty, right? So he's okay. So he says, I'll do it. I'm going to use it. And lastly, they say that his failure, that a county official's failure to timely canvass the county is likely given that Cochise refused to certify 2022. It's likely, like it's happened last time in Cochise. The complaint alleges that following this, the board of supervisors there refused to certify that, and there was a delay. They certified only after the secretary obtained mandamus relief against the board. But under the newly enacted provision, if they didn't do that, then they would just disenfranchise the entire county. Okay, last time they had to go to the courts, force them to do the job. They did it. But now he just says, you're gone. Actually, we don't want your votes at all. So there's some more standing stuff. They say, yeah, this is redressable. All right, you can fix this. Just don't enforce the provision. If we actually have a court order that stops them from doing this, it will redress the injuries because they will not be disenfranchised and more. Now, other people came in here and making similar complaints. AFPI is here. They've got interest in protecting their constituents. Now let's talk about the free speech provision. The court now assesses whether they can contest the free speech provisions. Now, as a threshold matter, the court concludes that the speech provision does regulate them. Why? It's broad. The speech provision prohibits any activities by a person done with the intent or effect of harassing, intimidating voters. Now, the rule lacks any geographic limit. It prohibits speech both inside and outside the voting location. And other companies and organizations say that our activities might fall within this. And so therefore, it covers them. Now, as the people filing the suit have explained here, they're not modifying the speech provision. There was a 14-day public comment. Legislature was unhappy about it. People talking about this violating the First Amendment. And if it doesn't regulate speech, if this is for something else that doesn't regulate speech, you should have modified the manual to talk about that, but you didn't do that. Earlier, they sent a bunch of letters to the secretary and the AG asking them to disavow the speech provision. But But they refuse to do that. And so it seems like they are going to enforce it. So it's a real thing. Now, lastly, the threat of enforcement is also further bolstered by likelihood that the speech provision will be enforced by election officials and poll workers at voting locations, right? They got the rule book. They got the manual. Now, they think there is a credible threat of this, and people have self-censored as a result. And let's see what else is good in here. So the court was not going to abstain from this, and then we get to the motion to dismiss. All right, so here's some better stuff. Now, the government wants this lawsuit dismissed. Adrian Fontes moved to dismiss this. He says there's no claim here, and they make several allegations that we do have a claim. First, they say the canvas provision is burdening the right to vote. If you disenfranchise an entire county, their vote doesn't count. The plaintiff says she's a registered voter in Arizona. She's going to vote. Several members of this organization are also going to vote, and the provision threatens to disenfranchise every single person in the county. So we could be disqualified. It's not good for us. Now, considering that, yeah, this could be a severe burden. It could come up. We don't know. The right to vote is fundamental. And if they can just disenfranchise the whole county, that's going to harm this person. So they do have standing here. And so the motion to dismiss from the government will be denied. Now, the court now turns to the free speech provision. They assert here that they engage in constitutionally protected activities that are prohibited by this provision. They argue that it violates Supreme Court precedent by criminalizing speech without a culpable mental state. They contend that it improperly prohibits speech merely for being offensive, which is already established under the First Amendment as something that's allowed. Offensive speech must be protected. Plaintiffs also allege that the speech provision is unlawful. Now, by its plain terms, just reading what's in the rule book, the speech provision prohibits any speech that offends or insults another if it has the intent or effect of intimidating, harassing, or threatening a worker. Now, that rule provides no geographic limitation, as the prohibition extends to any activity inside or outside the 75-foot limit at a voting location, right? So there's a line in it or out. So I guess it could go all the way to your house. Thus, the speech that a listener finds too loud, too offensive, or too insolent, potentially anywhere in Arizona, is prohibited because Adrian and Mays and Hobbs don't want you to hear about it. But it has long been established that speech may not be prohibited. Now, while a court is not required to accept legal conclusions, they find that the speech provision infringes on their right to speech. Now, they also say this is unconstitutional because it violates the due process clause. Nobody even knows what this means. The law is unconstitutionally vague so that you can't apply it. The rule prohibits way more speech than state intimidation laws do, and that violates fair notice. Under Arizona laws, speech knowingly made to intimidate or coerce voters is prohibited. But under the speech provision, speech is prohibited solely based on reaction. Okay, see these words here? Knowingly made, knowingly. So you have a mens rea, you have a mental state. You intended, you knew that the things you were going to say were going to intimidate, and you made those statements anyways, knowing that it was going to cause that or intending to cause that. But here, doesn't matter. If somebody is offended, it's based on the receiver. Because the speech provision is inconsistent with state intimidation laws, yeah, nobody has fair notice of what's even prohibited. And the rule prohibits offensive and insulting speech. Doesn't even define what that means. Why is a red hat offensive to you? Without any limitation, election officials and poll workers have nearly unfettered discretion in regulating a voter's speech. The failure to ascribe any meaningful standards here to the prohibited speech increases the likelihood that this is going to be arbitrarily enforced. And so accordingly, we're not dismissing it there. Now, they want us, the government, to not have these things implemented in the manual. So now we're going back to the plaintiff, the people bringing this claim. Can they force them to revise the manual? They give us some analysis. Now, no one disputes the right to vote is fundamental. Now, given these competing concerns of trying to regulate and govern elections, making sure everybody votes, we have to ask ourselves, was there a burden on the right to vote by Adrian Fontes implementing his little election changes? They say the canvas provision here is utterly without precedent. Just get rid of an entire county of people. Those are the Democrats. If the right to vote is the right of qualified voters to cast their ballots, it's to have them counted, not just to fill out a piece of paper and say, I voted. This imposes the most severe burden, state-sanctioned disenfranchisement, so that they can just get rid of the problematic counties. Okay, those counties are red counties. So if they could just nuke 1,000, let's say, Cochise is not a huge county, but let's say you got 10,000 votes. That's maybe dispositive in a close election. Indeed, defendants even agree on this point, stating that if plaintiffs in fact voted and their votes were not included, that would constitute a severe burden. Yeah, obviously. Now, the magnitude of this harm, if triggered, is severe, all right? At oral arguments, the government stated that there are 2.4 million registered voters in Maricopa County. Now, under this provision, all 2.4 million, right? So they made this provision so that they could just get rid of Cochise and Yavapai and some of the other red counties in Arizona. But the judge said, well, what about Maricopa? They're in charge of Maricopa. Obviously, it's big, it's blue, it's where Phoenix is. And that's, Chris Mays, Katie Hobbs, Adrian Fontes, they're all right there downtown hanging out with themselves. So they would never imagine that Maricopa County would be excluded. So the judge just says, well, what if we just exclude Maricopa? How about that? Could we do that? And they said, well, yeah, technically we could. Oh, okay. So according to your manual, you could just dump 2.4 million votes out. Are you nuts? You're going to exclude them based on the actions of a quorum of Maricopa County Board of Supervisors and Adrian, the secretary? Like, are you guys nuts? You think Trump's an insurrectionist and you're trying to change a manual so that Adrian can just disenfranchise everybody? Other jurisdictions have recognized that disenfranchising even thousands of voters is a severe burden. Now, the burden here is also classified as severe because it operates without the fault of the voter. The court has recognized that this is a big deal. This is why courts have routinely held that voting prerequisite laws often impose only a slight or minimal burden on voters. But in Arizona, under this scheme, this is a case of threatened disenfranchisement en masse, a threat realized by the actions that are all done at the discretion of little dictator Fontes. A registered voter in Arizona may perfectly comply with all voting requirements and obligations, but nonetheless have her vote excluded based on the public officials. So therefore, the burden is severe. Now, the government even agrees that if the secretary effectuates that and does disenfranchise it, it would be severe. But they say, but it's not realistically severe because likely it's not going to be enforced. But we don't care about that. And so the court is finding that there is a credible threat of enforcement here. And if it is enforced, it's a severe burden. Now, they say that they're justified in doing this. We have to do this. It's necessary. It's better for election results to be final. We want things to be done rather than accurate, right? Get us the votes to us now. Well, what if they're not accurate? We want them now. Well, what if they're, problematic? Then we're not counting them. It's better to disenfranchise a few, they said, rather than potentially millions as opposed to all. But what value does finality accomplish when it is attained at the expense of democracy? Great question, Judge. The government have not provided this court an answer, and they've not demonstrated why it's necessary to burden our rights if there's many other alternatives to ensure finality and to stop the disenfranchisement of the voters. Even if the government proffered justifications, even if they were compelling, the provision is also going to fail strict scrutiny, constitutional muster, because it's not narrowly tailored to achieve their state's objectives. There are other less burdensome alternatives. For example, the court asked during a conference, well, can't the manual, instead of disenfranchising them, like rather than just not counting them, can't you say something like, well, in the case of a county where the county officials don't certify, the Secretary of State shall be designated to make that certification in place of the county board of supervisors. Wouldn't that be an appropriate remedy? So like you can just take the position, like the secretary makes the decision over the board. You just give yourself that rule. So then you just say what the final number is and accept that number. You don't just disenfranchise the millions. Is that better? Like that's one thing you could do that's different than this. Because here we have an option of disenfranchising millions, or you could just accept the number for finality and then we could come back and figure it out later rather than just disenfranchising them. Is that possible? The government said it is possible. Yeah. Oh, so there's other things you could do. Their briefs reiterate there are other less nuclear alternatives. Mandamus relief like they got. They could prosecute unruly county supervisors. And they said, well, what happens if it is triggered? Well, they said we'd probably go back to court anyways. They said the secretary is committed that he'll do everything within his power, including filing a mandamus seeking other court intervention to avoid this canvass result. Okay, so just do those things. You don't need the provision in the manual then. Yeah, I don't disagree that mandamus is the way to resolve this problem, they said. Yeah, so you know how to do it. Now, in addition, there are other alternatives. There are other less restrictive means. The secretary could certify in lieu. They could get a declaratory judgment and do other things. And so it's not narrowly tailored. And therefore, if it's infringing on a right, it should be the, compelling and narrowly tailored. This is not. Now, is there irreparable injury here? Of course. If they enforce this, the harm, mass disenfranchisement, will be irreparable. Their votes will not count. The whole election might change. And so if we balance all the equities, we have to determine whether this will favor the plaintiffs. The prohibition is broad, and the speech provision would prohibit any person from intimidating a voter. And the final clause is also broad. Accordingly, by its terms, this speech provision is a broad prohibition on activities, including speech anywhere at any time, so long as it's done with the intent or effect of intimidating a voter. Because it's ambiguous, we don't really care about its meaning. threatening. We're not going to investigate it further. At the heart of their arguments, they say it's necessary, right? People will say bad things at election polling places. And so obviously, if they're trying to regulate speech, we have to analyze it as though they're trying to regulate speech. Now, as the court noted, the First Amendment overbreadth doctrine permits courts to hold a statute facially unconstitutional, even though it has some lawful applications. It's just overbroad. This speech provision broadly encroaches on a substantial amount of constitutionally protected speech. Here, it allows election officials to use their sound judgment, I'm sure, to remove voters for using offensive or insulting speech. If it's too loud, if it's too offensive in the eyes of some rando, then you can be thrown out of the polling place. The provision also imposes liability for speech if it has the effect of threatening. The effect. This lacks a mens rea. We need mens rea, which is a guilty mental state. And so it's also void for vagueness under the Due Process Clause because nobody knows what it means. You can just be prosecuted, essentially, thrown out of the polling place. No one has fair notice of what this means. There's no meaningful standard for defining aggressive behavior. The defendants make their arguments. They say it was adopted a long time ago in 2019. So let it be. Nobody complained about it until now. And they said, well, now we know. This is when members publicly expressed concern in 2023. And so now we're considering it. Now, plaintiffs have established a First Amendment claim. They've alleged they've self-censored intangible injuries happening here. And so now we need to talk about the public interest. And so accordingly, it is ordered the following. The government's motion to dismiss count 2 is denied. We have some standing issues. And as you can see, boom, this is the victory. The government, Adrian Fontes, is enjoined from enforcing the canvass provision during the pendency of this litigation. It's also ordered that Fontes and the government are enjoined from enforcing the speech provision as well. And it's finally ordered that the government must answer this complaint within 14 days. So we're looking at a response in early to mid-October, and we'll see what the government says in response.